Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Newman versus Bost. This case was heard in the Supreme Court of North Carolina in the year of 1898. Let's go ahead and jump into the facts of the case. So the plaintiff was a lady by the last name of Newman. Her first name was Julia. Julia was a housemaid or a servant of a gentleman by the name of J.F. Van Pelt. J.F. Van Pelt was a wealthy businessman in early North Carolina. And she was his servant. The named defendant in this case is Bost, and that is the heir to the Van Pelt estate. So Newman is suing the heir to the estate for some things. And you'll see that this case deals with acquisition by gift, and we're going to deal specifically with constructive delivery of a good out of gift. So let's go ahead and jump into the facts of the case a little bit more. So Newman was a servant. She was at Van Pelt's house. Van Pelt was paralyzed and he was bedridden. He was about to die. Van Pelt called for Newman. Newman came up to the room. Van Pelt handed Newman a bunch of keys and said, "Hey, I want you to have all the furniture. All the furniture here is yours. I want you to have it. I want to gift this to you." Now the will had something different in it, but the gift superseded the will. So Newman was bringing suit saying that, hey, I should actually have the value for all this furniture because she wasn't given that by the heir of the estate. She should have all the value because Van Pelt promised this gift to her. So the court thinks about this a little bit, and they're trying to deliberate whether this was a gift and whether it meets the threshold for gifts. So the first threshold for a gift is that the donor intends to give it to the donee. So we satisfy this criteria pretty easily for Newman because Van Pelt did intend and he gave that to her. Court talks about how there doesn't need to be any witnesses for this type of a gift, which it refers to as a donatio causa mortis, which is Latin for a donation in prospect of death. So that's what we're dealing with. And he says, he does intend to give it. So then the court discusses a little bit about delivery. Delivery in the law of gifts, generally in English common law, it had to be an actual delivery of the good. If you were gifting someone land, you needed to grab like a clump of dirt off the land and give that to them. But there needed to be something physical accompanying the gift, a symbolic gesture, just saying, hey, I give this all to you, didn't necessarily work. So the court tries to see if there is this actual gift, whether there's something physical behind the actor Van Pelt's intention. And it turns to a group of keys. These keys that Van Pelt handed Newman before his death. So the court says that, hey, Newman, you might not have access to everything in the house, all of the furniture in the house, but whatever he gave you the keys to, and whatever furniture was around there that he couldn't lift up and physically hand to you that was in his vicinity, and was in your quarters, is certainly yours. So that's how the court rules. It says that if you can't pick it up and physically hand it to someone, constructive delivery would be, saying that that's yours, and then whatever he gave her the keys to would be hers. The final question is, there was a $3,000 life insurance. This is 1898, so quite a bit of money. A $3,000 life insurance policy in one of the pieces of furniture gifted by Van Pelt to Newman. And Newman says she wanted this $3,000 life insurance policy and that Van Pelt meant to give her this. So the court considers that a little bit, and ultimately they say that while she will get the furniture, she's not going to get this $3,000 life insurance policy. The reason they say is because if Van Pelt wanted to give her that life insurance policy, he would have mentioned it. He would have said, hey, I'm going to give you this piece of furniture and the life insurance policy, so make sure you don't miss that. Or he could have had someone physically hand her the life insurance policy. So that is where it doesn't go in favor of Newman, but the rest of the furniture that was in the vicinity that Van Pelt couldn't have physically delivered and handed to her, and what was in her quarters, and then whatever the keys that he gave her unlocked are hers. So this is key to establishing a doctrine of constructive delivery, one where items don't actually fully need to be physically handed from one person to another in order to be gifted. Rather, an exchange of an item, a physical item that gives someone access to that furniture, be it the key in this scenario, is sufficient to constitute that delivery of the good. So now that that's the case, that's the brief, that's what you need to know for class. Let's go ahead and jump into some ex ante implications. So first I want to pose a hypothetical scenario and see if I can just pull at your strings a little bit. Let's say that, heaven forbid, your father is walking on a busy street and he gets struck by a car. He feels like he's about to die. And he sees a hobo, and he feels bad for this hobo because our fathers are good people. He feels bad for this hobo, and our fathers are exceptionally rich. They have Ferraris. So what if he just handed this hobo his Ferrari key? He said, hey, this is yours. I want you to have this Ferrari and, go sell it, buy a house, begin to live your life. You, and especially me as the son of someone, might feel really angry that, hey, this is, my father had written out in his will and testament that I would be the owner of his Ferrari if anything happened to him. How does this hobo get this Ferrari because my dad just handed him the keys? Well, upon the basis of constructive delivery, that being the key, that would actually satisfy the component of a gift and a donatio causa mortis, a donation in the face of death is what it's Latin for. And that homeless man would actually have possession to the Ferrari and not you. So it supersedes the will. And it's something to think about. The policy considerations for that are, one, we don't want to rob people who are on their deathbed of their legal rights to, bestow gifts on other people. They probably get a lot of joy from that at the end of their life. Like, I imagine Van Pelt got a great sense of joy knowing that he was going to give his housemaid, quite a nice sum of money that she could do what she wanted to with. But in addition, do we want to give that right to people who are in such a vulnerable state of mind where they just feel like, I want to give all this stuff up to whoever's around me, when perhaps in a prior state of mind, when they had more clear judgment, they were very prescriptive about who they were going to give that furniture to, in the case of Van Pelt, and in the case of our hypothetical, who he was going to give the Ferrari to. So something to think about. The policy considerations are, do we want to fully bestow someone who's on their deathbed the right to gift property when maybe they aren't in the right state of mind to do so? Or do we want to trust a prior version of themselves who maybe was in a better state of mind to decide what they want to do with their property? And the case does talk about that a little bit. It's just something to think through. So thanks so much for watching this video. I hope you enjoyed it. If you'd like to see more, go ahead and hit that subscribe button. Hope you have a great rest of your day. Bye-bye.